A little robin's just arrived. Are you going to come into shot? Nope, never mind. Right. Kier and the Cannibals. Can I justify that clickbaity headline? Yes, I can. And how can I do that? Well, I want to take you back to 1884. Four guys were delivering a yacht to Australia. The yacht capsized, they ended up in the lifeboat. They were stuck at sea for 38 days. Things, as you can imagine, got a little bit desperate. So they did what was the law of the sea at the time. They drew lots. And the cabin boy, one Richard Parker, lost that draw, which I'm sure was completely fair and not rigged. So they ate him. They duly arrived back in Falmouth. People are going, oh, that's terrible. Oh, that's quite an ordeal. But they were prosecuted. And they were prosecuted for murder. And their defence was, well, hang on, this is the law of the sea. It's a defence of necessity. Because had we not done what we did, I mean, this kid was on his last legs anyway, not only would he have shuffled off this mortal coil, the other three of us would as well. So 3 people lived, whereas had we not done this, like 4 people would not have lived. But the courts established and said, no, necessity is not a defence to murder. And that is still the law today. And this cropped up after September the 11th with all the stuff about could you shoot down an airliner. Arguably under English law, no, you can't, because even though that might, save thousands of lives on the ground, you're still not allowed to do it. The argument is English law says, no, of course, every decent English person would quite happily sacrifice themselves. Not quite sure about that. It did crop up also in that Townsend Torreson, spirit of free enterprise, a herald of free enterprise. Somebody froze on a ladder and they got stuck as they're trying to evacuate, so they literally just pulled the person off the ladder and they fell down and didn't obviously survive. But a decision was taken that it wouldn't be in the public interest to prosecute, even though, realistic prospect of conviction, because on the facts there was no dispute they'd committed the offence. But that eliminates necessity as a defence to murder. But is it a defence to anything else? Yes, it is. It's a defence to everything else. So what is necessity? Necessity is where you commit a crime, but your justification for doing so is that by doing this one bit of minor wrongdoing, you have prevented another bit of more major wrongdoing. So it was necessary to do it. So what's the wrongdoing? What's the harm you're trying to prevent? I mean, it doesn't have to be, lethal harm. It can be any sort of harm, but the idea is that it's more serious than the thing that you did wrong. I mean, the classic example is normally it's criminal damage if you smash a car window, but if you see a dog in there that's overheating, then you are allowed to do it. It doesn't matter that the thing you're trying to prevent isn't itself illegal, and this will crop up with all the war protests, because arguably what's going on, is perfectly legal under domestic and international law, but people are saying, well, yes, but people are still being harmed as a result of it. So us say it's sabotaging equipment and preventing that. That is our defence. It doesn't matter that there are alternative means of achieving that. So if you say, well, actually, you could have lobbied, or you could have campaigned, or you could have petitioned, or you could have even done, a lesser offence. It doesn't actually matter. But ultimately, this is a mixture of fact and law. So it's up to the judge to decide whether a defence of necessity is possible, whether the actions are capable of amounting to a defence of necessity. But it's up to the jury, if the judge allows that, to actually decide whether or not that did amount to necessity. And a lot of the time judges will say, well, no, because you fail at the first hurdle, because there's also got this idea that the harm you're trying to prevent is imminent. So it can't be just some nebulous thing. It has to be, I have done this specific act, like I have rescued this one particular dog that was like stuck in a heated car. If I just went around randomly breaking car windows just in case anybody left a dog in there, then obviously that wouldn't count. So that's the defence. Now, what's this got to do with Keir Starmer? Well, back in olden days, when he was a barrister, he acted for some people who had sabotaged some military equipment because they said it was to prevent sort of war crimes in the Middle East in one of the Gulf Wars. And you get to this interesting thing about, well, what amounts to a war crime? Because we often say, don't we? We say, like, it's not a defence to say I was only obeying orders. Actually, it is. It's not a defence to an individual war crime to say you were ordered to commit that war crime. But it's not for individual squaddies to ascertain whether the conflict itself is legal or illegal. And there have been cases on this where people have run necessity, for refusing to be called up or refusing to deploy, and they've said no, because I think the war itself is on an illegal footing. Now, if that is the case, then the relevant government can be prosecuted. I mean, that was a big issue at the Tokyo War Crimes Tribunals. They introduced the concept of waging aggressive war, as if there's any other sort. But they said, well, that's something that a nation, a state, or a military government can be found guilty of, but an individual soldier merely fighting can't be. So it's not a defence to say, oh, well, I refuse to deploy because I think the war is illegal. It'd only be a defence to say I refuse to deploy because once we're there, they're asking us to do individual war crimes. So anyway, Keir Starmer ran that. He acted for people running that defence. We sabotaged this military equipment because we thought it would prevent a greater crime. Now, I can't even recall whether he was successful or not. I don't think he was, actually, because I think I know the judge. But what people are saying, well, isn't that a little bit inconsistent now that they've talked about prescribing Palestinian action, making them a prescribed organisation because they broke into Bryce Norton and they sort of vandalised. They threw paint on some jets, which obviously, they still need to be checked and serviced because they're very delicate pieces of kit. But it's probably fair to say that, with a bit of scrubbing and repainting, they're probably fine to go. But the fact is, it was criminal damage. So their defence would be, well, we did this as a matter of necessity. Now, they might fail there because they've done it on the basis that these were flights supporting what was going on in Israel. And it appears that they weren't. These were flights that are supporting British actions in Syria with Daesh, as we now call them. It's actually one of my old Chambers mates, who's now an MP, who sort of started the trend of calling them Daesh, not ISIS. But yeah, so that's what that's what they're running. So they might be in difficulties because what they are, defending against, the reason they did their actions isn't actually the right one. They were acting on duff information, or they got it wrong. So that'd be an interesting one, whether they could argue and say, oh, well, in that case, even though we got the wrong thing, then we should still have a defence because we were preventing another injustice or another harm. We just didn't see what it was. But does this establish a precedent? Well, no, it doesn't. Because each case turns on its own fact. These are first instance cases, and like I say, necessity is a defence you can raise. If you can allow the judge to put it before the jury, if you can say, well, these actions are potentially capable of amounting to a defence, the judge will let it go to the jury, but sometimes you fail at that hurdle, and then it's up to the jury. But first instance cases don't set any precedents whatsoever. They're not binding on any other court. I mean, for everything else, it's just a jury decision, isn't it? Now, there might be some rulings within that case. Let's say, for instance, the judge says, I'm not going to allow you to run this defence. Then you might actually appeal that down the line and say, well, in that case, let's just go straight to verdict, because if you're not going to let us run it, we don't have a defence. But then they might appeal. And if the appeal says something like, it probably confirms a yes, necessity is a defence, but it probably say, however, everything turns on its own facts, and it's up to the judge whether they found as a matter of law mixed fact whether this did amount to a defence. But what if you can get what's called termination rulings, where if a judge says, I'm going to make a preliminary decision on a case that would actually scupper the prosecution can say, right, if you make that decision, we will have to drop the case. Now, if they say, well, if you make that decision, you'll make our job a bit harder, but we'll still go on with the case, that doesn't count as a terminating ruling. But if they say, if you make this decision, we'll just throw the towel in, then there can be a pause. Well, they go off and they check that with the Court of Appeal. And then the court can come back effectively mid-trial and say, actually, no, that ruling is wrong, so the judge was wrong, carry on prosecuting. Or they might come back and say, yeah, the judge was completely right. In that case, you've thrown the towel in and that's the end of the prosecution. So you can get sort of things like that. But generally speaking, the mere fact that in one case, they've run necessity doesn't mean that that's established a precedent generally. Like I say, it's always been accepted that necessity is a defence at law to everything except the M word. So there's nothing new there. It's just applying the facts to it. And then we get into all this cab rank thing. The fact is, I'm a big proponent of cab rank. That's the idea that barristers must take any work that comes their way, so long as it's something they're qualified to do and people are willing to pay for it, and you've got the time. I do that I'm a big fan of cab rank. I do cab rank even if it wasn't a rule. Technically speaking, under direct access, cab rank doesn't apply, but I pretty much do apply it. If somebody comes along, even if it's something where it would affect my reputation, or it's a distasteful client, or a cause I totally disagree with, I just do believe that lawyers shouldn't be the filter. Everybody's entitled to the best representation they can get, regardless of the cause. So I'm a fan of that. But yeah, in this particular case, they're sort of saying, well, how can Starmer at one time to be, arguing organisations should be prescribed, but on other times he's defended organisations doing similar things. Well, he was doing two different roles at the time. He was being a barrister at one case. And I'm sure, the chambers he was at specialised in these sorts of cases. And yeah, there are ways around cab rank, but there's ways around all sorts of things. I don't think you should say a law should just be abandoned just because lots of people find loopholes or ways around it. It's not like we live in a crime-free society, but we still have laws against crimes. We don't sort of just give up because they're not necessarily effective. So there you go. So that's that. I think I can justify that was Keir Starmer and the Cannibals. So to summarise, there is a defence called necessity that people run quite a lot. I've tried running it in a few cases. Starmer ran one in the past, but that has no bearing on anything that happened in the future. So anyway, as always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. I'm just down at Cows and Sows. I actually came here and they were shut. I didn't realise that, but they still made me a coffee because that's how nice they are here. And I'm just waving, and I'm going to come down on Saturday because apparently they've got some owls, so I want to see those. And it was because there's all sorts of people here who like rehabilitate birds and stuff. There's one lass who's got like about a gazillion crows. I think she's just sort of training up to be some sort of like secret super army of atomic powered super crows.